we're recording, but we're going to try to personalize a little bit. And I hope that more of my students visit the course questions forum. Let's see, what is it called? It's under discussions. It's a change we didn't, course chat. I hope more people visit course chat and introduce themselves to me, and then I have introduced myself to the class there. We used to do it all in student lounge, but the higher ups decided that that the student lounge was going to be just about students, and the course chat was going to be more faculty and student. So social distancing is a little different with online than it is with in person. Um, in online, we tend to be too socially distanced, if it makes any sense to folks. We tend to be 1,000 miles away and total strangers, and that's bad from my point of view. That's too much. Um, you know, on the other hand, too little social distance would. I created a class in the banking and finance, or I should say not in banking and finance, but I created a class in finance that my daughter-in-law ended up taking. But I was just as glad that I was not teaching it, because that would have been almost like a conflict of interest for me teaching her in competitive college stuff. What do you folks think about that? That sort of leads into what we're going to do today anyway. What do you think about that? She took a class I created, but not from me. What do you think of that?
Um, it, I don't want to offend you, Mr. Olson, but I guess it could seem like a conflict of interest.
Right.
Or maybe if another student got wind of it, like, oh, well, her father created that course, so she's going to have the upper hand. She's going to know information, even though I'm sure ethically that wasn't the case, but I could see it perceived that way.
Yeah. Well, um, she studied very hard. She never asked me a thing about it. Um, there's no, there were no hidden tricks to it or whatever. It was not essay based or something. I mean, it was not quiz based or anything like that. Anyway, it was a um, thinking and doing your own thinking um, course, and she took it for accounting, and some others took it for business. I created it for business, and it was just interesting because nowadays I wouldn't be creating a finance course, but um, it was small business, and um, but it was interesting. After she finished the course, I said, "What did you like? What did you like about the helps I built into it?" She didn't use any of the helps I built into it. I had uh, websites to use, and I had some pre-done um, things like Excel spreadsheets. She didn't need any of it. She was very brutally honest. I said, "How about the storylines?" Because I had put in about the little shop that later on got big. She says, "I didn't care about the storylines. She's a numbers person, so she just did all the numbers her own way, and she didn't. She did her own spreadsheets." You see what I'm getting at? But she probably would have been annoyed taking the class from me and said, "Well, you don't need to tell us all that." So, uh, and of course, then I switched over to after I did that, created that course, I'd switched over to paralegal. So, uh, one of the things we're going to be talking about is um, the main thing we're talking about is conflict of interest, which is not the whole subject of loyalty. Loyalty is a bigger concept. Conflict of interest, you might say, conflict of interest is when loyalty is not rigid enough, not perfect enough. So the positive side of it is loyalty. The negative side of it is when loyalty goes wrong or is incomplete, that's conflict of interest. Loyalty, the legal loyalty goes back hundreds of years. I even have a breach of loyalty story from over 2,000 years ago, reading from an old book on Roman lawyers from many years ago. And I'll get back to that if necessary here, or if folks want. One of the things that you want to do in this is hold me accountable in terms of if something in the course, I did not create this course, somebody else did, but if at the end of this module, the objectives don't work for you or you feel like you didn't achieve them, I'm accountable to help you meet them. If this does not make any sense, or this doesn't make any sense, this ethical wall, conflict checking, if none of this if some one of these doesn't make sense, contact me and let's go over it. Let's make sure that you get it. Same for all the other module objectives. If you meet the module objectives, you're ready on the ethical side of legal work. Now I guess I'm going to go back and say, I do want you to say something you're looking forward to this fall, if you're willing to do so. And I'm looking forward to hunting with my deceased brother's pals. My brother died after hunting last year. Not the big hunt, but he died in the winter in December, and his pals that have gone hunting with him for years have allowed me to come with them this year, so I'll be with them on the hunt. So that'll be nice. Not that I'm replacing my brother, but just we're all going to think about him as we go out there in another week and a half. So that's what I'm looking forward to. He has wonderful pals that he hung out with, and you know, who else is looking forward to something this fall?
What is something we're looking forward to this fall?
Yeah,
Personal or professionally?
your choice.
Um, I'm looking forward to just, I'll be done with this program in May. So just, for me, just learning out as much as I can and doing the best that I can, academically. But, really, when I was getting my master's degree, I was, teaching full time. So it was kind of hard to balance. And now I'm just a mom, and I say just a mom. So I feel like now I can kind of really hone in on the practice of the paralegal. So
Okay, wonderful. I, I can look in the chat, but if you can unmute, say hi and name something.
Mine is a little bit more personal. I'm going on vacation in about a month to Puerto Rico, so I'm looking forward to that.
Yay. Sounds great, Becca.
Yeah, nice and warm there.
Right.
I'm very excited to take my husband, my stepboys, and my newborn baby where I was born up in Pennsylvania. I'll actually get to take them up for Christmas, and I'm very excited for that. I haven't been home in over 4 years due to the military, so I'm so excited.
Oh, yay. Yeah, well, that'd be wonderful. Family time. How about Jennifer? Can you say something you look forward to?
I'm actually kind of looking forward to seeing the kids in their costumes on Sunday and passing out candy because I didn't do it last year and I do enjoy seeing the kids in their costumes, especially since I don't have any kids.
Oh, neat. Christina?
I don't know if it's something I'm looking forward to, but speaking of Halloween, we have my daughter has all kinds of Halloween activities planned this week and over the weekend. And so we're just kind of keeping busy trying to transition from the summer to the fall.
Neat. That Halloween reminded me, the scariest costume I ever let either of my kids wear. My younger boy must have looked up to me because he wanted to go out um, looking like me, and he borrowed one of my hats. I had a kind of a nice hat, and I don't remember how my wife did the top coat so it wouldn't drag, but she figured out how to make the top coat work. And so he was dressed up as a lawyer. So as a young boy, uh, he looked like there was a lawyer movie with Danny DeVito, Danny who was quite short. You guys know who that is? Anyway, it was sort of like Danny DeVito coming to serve papers on table. I'm sure that was terrifying to the neighbors to see a very short lawyer going to their house with a briefcase instead of a bag. uh, and of course, it wasn't terrifying because I was a little boy, but they pretended like they were scared. The neighbors did, so that was fun. The only one I've ever heard of do that. I've never heard of anyone else go out on Halloween as a lawyer. I was a practicing lawyer at the time, so they knew. And Brent is such a small town; everybody knows whose kid is whose, or did at that time anyway. Um, Now we're going to tackle something um, that can be a little difficult. Um, I am letting you um, begin your research and use these things with the ethical wall and the model rules. Okay? But notice it says begin, it doesn't mean end your research. So yeah, we want to understand more about the ethical wall, which is um, a big exception to a subtle rule, okay? And we'll talk about what it's a big exception to and what the subtle rule is. Um, we'll talk about the plain, simple conflict of interest and work our way into the more subtle one and the other. But in terms of sources, um, in the past, some students have said they're only going to use these two things, model rules and ethical wall article that's been given to you, but that's not enough research. Who knows why does Kirk, in other words, me, want us to use primary sources of law, like state rules? and I'm typing it out on this page. How come I want that?
Well,
You've already
primary
got-
sources of law are proven as opposed to opinions or things that haven't been, you know, I can't even think of the word. Things that haven't been acknowledged yet or accepted yet. Secondary sources could be legal papers, things that may not necessarily give us the true and accurate picture.
Right. The other thing is just skill building. And I'm having a little trouble both from above and below me. I'm having trouble because I'm all about skill building, and a lot of my students are more about basic knowledge. I understand that basic knowledge helps, just sort of absorbing a bunch of basic knowledge. But if you learned 100 different facts about legal ethics, but didn't build any skills to update legal ethics, I feel like in 5 years, you're not going to understand what's going on. Whereas if you build these skills in terms of looking up your actual home state enforceable rules, if something comes up, or even if something doesn't come up but should, in other words, your firm should be doing a better job with something, you won't know. But if you build skills and you keep up with your routine research of just looking up to see, have these rules changed, what has changed, what hasn't in your home state, then you're equipped, not just for the next year after you graduate, but you're equipped for years and years and years. Let's say that they radically change the conflict of interest rules. Your memorized knowledge will be not useless. You'll still have some basics that will help you make sense of it. So not truly useless, but not nearly good enough. But if you build these skills, and I will say mindset rather than just skills plus mindset, the mindset of the fact that you not only can but will look up your home state's actual rules, you're equipped. I mean, that was something that my favorite judge, Judge Flora, who used to be from Minnesota, he moved to Florida for some reason. Must think the climate is better there. He stops by sometimes in the summer up here, and I get to see him. But favorite judge, kind of a mentor. But one of the things he said, he was a mentor to all the lawyers, not me personally. But one of the things he said is, you've got to keep reading. And you would think, well, you don't have to tell lawyers that, but sometimes lawyers get lazy a little bit on continuous reading, and so he reminded us, you have to keep reading. Make sure that you do it. Don't use memorized information about the statutes, the rules. I'm going to enforce the rules as they are now, not the rules you remember from last time or last year. So I hope that makes sense. My students need to know this, that I am a skill building person. I need to explain it better to the dean that I work for. My comments are mostly my comments in grading. A lot of it has to do with skill building stuff. Your contents, your actual answers are almost always correct. So I really have very few comments about whether you were right about something being right or correct or wrong or whatever. You know that. But where did you get it? Are you building your skills? That's where I come in strong. And are you explaining it the way you would in a really good law office? Is it clear? Is it clear when you write a paragraph, whether that's yours or a source's? If you cite a rule of professional conduct, you cite a rule of professional conduct right after you quote or paraphrase, then I know that that's what you're talking about. it's not you talking yet. Then after that, you have some unsighted material, then that is your personal idea. Can't write material there, stuff. I know they tell you in high school not to use the word stuff. But anyway, you have the sight, and then you have the unsighted stuff. And the unsighted stuff um, should should be your personal ideas. It should not be so-called general knowledge or something like that. General memorized knowledge is not what I'm talking about. What I'm talking about for unsighted stuff should be your personal ideas that are yours and yours alone. That's my opinion on how you build these skills. Then when you're in the law office, the lawyer knows precisely what you found, where you found it, and as they skim through, they can easily grab onto what you personally think. One of the things you might be thinking is, I'm lost on this stuff. And that is a legitimate thing to report to the supervising attorney, just as it should be when you're in class. I'm lost on this concept should be something that you fearlessly report. I missed this concept. This law doesn't make 100% sense to me. This law makes sense, but the application is hard because we don't have enough facts on that issue. Questions, comments about what I'm talking about here? Early in a case, if you never complain about lack of facts, you're not paying attention. Early in the case, the fact that there's going to be interviewing tells us something. If you had enough facts to know everything at the beginning, you wouldn't bother to interview people, would you? So, as you start a case, there's always fact gaps. As you cope with an academic case, there are fact gaps, most of which don't matter that much for the concepts, but some of which do. Last week, there was a giant fact gap that we could drive a truck through. And I talked about it, but most students, and I've graded most of the, let's see, graded about 2/3 of the assignments that were turned in, I think. And I'm going to finish the rest tomorrow. But a bunch of students did not catch one of the fact gaps that would make a difference on the timeline. And a couple did. And it is something I talked about in the live class. Yes, there is a fact gap there in Module 3. There are fact gaps everywhere. But of course, they don't all matter for the legal issues, and some do. For this week's, the citations go in the answer and reasoning, not at the end. Never at the end, never at the end, never at the end. Never use a reference page in my class. And I realize most students are doing what I want there, but there's still some that seems to insist on using a reference page, and I don't know why. It's not like I don't have it in a bunch of announcements and documents and other things I've sent you. Those that are using reference pages, they should see at the top of their comments. Don't do that. Then they do it again anyway. Don't understand that. What you do in class should be as similar as possible to what you would do in a good job, a really good job you want to keep. If somebody said, Mr. Olson is right that there's no reference page, but I want you to do a table of cases and other authorities, and I want you to do it just like this. If the boss says to do that, then you go to your state's information and you find out how to do a table of cases and other authorities. I still think, even if you do those, you should still follow Blue Book and also cite the way I showed you. because that's required by Blue Book, and it also makes sense of things. Otherwise, if we mix up and garble which part is from, let's say, a statute or a rule and which part is from you, it's just a mixed up paper that the lawyer can't use very well. And then the lawyer, when the judge gets it, even if the lawyer has adjusted it a little bit, the judge will look out over his glasses and say, Counselor, I can't tell which part of this is the law and which part of it is your stinking point of view. And I realize judges these days are not all as blunt as they used to be, but if they don't say it, they're thinking it. They want to know which part is the law and which part is our stinking point of view. And I love your point of view. I'm different than the tough judge, but you need to know there's tough judges out there, and they want to know the difference, which is the point of view part that you and the lawyer worked on, and which part is the law or the other sources, if there's a factual source or a source on something else. They want to know which part is from the source and which part is from you. I'm not super fussy about the memo format, but this is the format that you're given. You may also use a table in Microsoft Word. I like tables. I teach tables. If you want to use a table, I guess telephone me and we'll work on it. They are fun to do. All papers are in Microsoft Word or PowerPoint. If you don't have the Microsoft Office from Rasmussen, call support.
Mr. Olson, do you mean like a table, like with columns? I'm sorry, is that what you're referencing?
Yes.
Okay, so maybe you have, because it looks to me, this is like the IRAC, but but the A and R are flipped.
Right.
The previous course, we did issues, reasoning. Well, that was analysis, and then we did conclusion. But you
Correct.
literally like want rows and columns, so you maybe would say issue, bulleted point, or something like that. I don't.
Yep.
Okay, thank you.
Yeah. And I tend to totally redo it. If I did it in a table, I tend to simplify it way down. But I would tend to basically do a table for each issue, answer, reasoning, cite, or something like that. Let me do that. Let me do one for reasoning here. The one that where it really helps to do a table is when you go to reasoning. Yeah. Keep going back to there. Okay, I'm gonna take this microphone out of my way. Take a look at Microsoft Word. Okay. My problem is now this thing is in the way, so I can't. There we go. Oh. I need to zoom it up a little bit. Okay, can you still see it? Can you see the Microsoft Word doc?
Yes.
Okay, go insert. It's file home insert. Maybe different in somebody else's version of Word. And then you go table. And then you just make a table for the reasoning. So this would be the reasoning table. Okay. Because this is basically what I want. I want you to use a source, cite it, and then give your comments and thinking. So I could do a sample one. And I'm not typing this correctly. This is not correct citation since I didn't put capitalization and so on. And I don't remember the rules, so I'm just going to put rule 1.1. Okay. Okay. What do you think about this table? No, I'm not typing everything out. So I did a fictional cite. I didn't type out my paraphrase of the rule. And then I did some sample comments and questions. So questions as far as how this works. Must have put them in the chat. Okay, I'm not seeing it in the chat. And basically a table is just for the purpose of making it easier for you to tell if you got all the points. If you don't think the points have good reasons though, behind the points, of course, you definitely need to talk to me because just point getting for its own sake is not what we're after. Point getting for the fact that you are getting usable skills out of it. The usable skills include organization, organized thinking, which leverages from or is a byproduct of being organized. Your thinking becomes organized. And then, of course, it's forcing you to do research since the format itself that you just did at the top says you got to do a citation. So to do a citation, you must have found a source. To find a source means you did research. So you're forcing yourself to think and you're forcing yourself to do research. So I hope you feel like earning the points creates skills you'll use. Okay. Ethics opinion. This is ungraded reflection questions. This is just helpful, okay? What is an ethical wall? You definitely want to go with primary sources as much as you can, then secondary, and finally opinion. So you go with ABA rules, state's highest court rules. statutes, articles by attorney, and cases from the state's highest court. Sometimes I think it does help to have an instructor like me, because I don't agree with all of the stuff in the ABA. I think some of it is too easygoing. The ethical wall was intended to make mega law firms possible, but what if they cheated on the wall? How are we ever going to know it? So kind of put me as a skeptic, but I'm not willing to, I don't feel strongly enough though on my side to tell others to change the rules. If the state's Supreme Court came to me and said, we want you to write an article about this, tell us why you're against the ethical wall, I don't think I'd do it. I'd probably give them a pros and cons, okay? I don't feel strongly enough to rock the boat at this point. I'm just a skeptic, okay? I thought about it. Originally, I was against the ethical wall. Then I sort of got a little mushy on it, okay? There is no live classroom quiz for module 4. The ethical wall just means that even though there is a conflict of interest, if they screen the person who knows too much information from giving it out, then they get to keep employing the person. That's what the ethical wall is. There's a regular quiz which was created by a different expert instructor. I don't give credit for arguable answers that are not the ones in the answer key. I will help you a little bit in preparation. Don't use the term resources as a title in your memo. Resources are things you need to use, such as how do I create a memo, the assignment link, Microsoft Word, Lexis Advance, do your own research. These are resources. These are what we're calling resources. And call on me. We're going to learn the subtle parts of conflict of interest, but most are very simple. Extremely simple. It still pays to think about them because they're a building block for understanding the more difficult ones. A firm can't be against a client and for the same client at the same time. If a person wants advice on a divorce and the firm is trying to evict the same person, the new case needs to be rejected. So, and that's true, at least normally it's true, even if it's a medium-sized law firm and somebody comes in and says, well, I know that the guy in the other building, the other town, I know he's part of your firm and he's trying to evict me and he's a lawyer and now I'm going to you, but I want you to represent me in a divorce. It's any lawyer in the firm is disqualified. Okay? Does that make sense? I practice most of the time. I guess the most lawyers I've ever practiced with was 2 other lawyers. So we had 3 lawyers when I was an employed lawyer, and then when I had my own firm. Most of the time I had just me, and for a couple years we had 2 of us. I had a junior partner for a couple of years, but in any of those situations, I could not take a case if it was against somebody that another lawyer had as a client. And it sort of builds on that loyalty and confidentiality that we learned early on. The entire law firm is supposed to be loyal and confidential, not just the one lawyer that's helping them. Questions, comments about the regular basic conflict of interest? helpful comments for classmates?
So just quick question. So you said, because I did look at the assignment beforehand. I haven't done any of the readings yet. So you said a conflict of interest, if the person was screened, they can keep employing the person. And obviously through the research, but apparently on the assignment, she was not screened.
Right.
And then, okay. And just a quick question. So, you know, the law firm that I'm at is criminal defense, and there's so many cases that are coming in. So you switch to another, excuse me, you switch to another law firm, and is it like memory based? Like, oh, do you remember Kirk Olson was involved in that car accident? I mean, how do you, I mean, the flood of cases that come in of potential clients just on a daily basis, I guess how do you keep track of that if I were to switch to another law firm?
It's a mess.
Okay.
Because for one thing, your old law firm is not going to give you a card file index or electronic access. So um, it's if you ask me, it's kind of a mess. But to the extent they can, um, they try to avoid conflicts. But with employment, it is more difficult than it is with just individual clients coming in. Um, the I almost think to do a really good job of screening, you almost have to have the law firms cooperate somewhat with each other. Otherwise, yeah, it would be more memory based because they're not going to allow you to come in there with a complete, although maybe they will, especially in the corporation context. Not so much with criminal law, but in the corporation context, um, the fact that they do represent, let's say, they represent the Target department stores, that's not a secret. Okay. What they exactly do confidentially for Target stores, that may be confidential, but the fact that law firm represents Target's not confidential. Um, if a person at Target is possibly going to be charged with theft and is afraid of it, they come to your law firm. Even the fact that that person ever went to your law firm is confidential. Do you see where I'm coming from? So that's why I call it a mess, because the fact of being a temporary client, maybe the person came in and just got some advice and said, "Well, you really didn't steal it. You were boxing things up, and your kids came, and your teenager, and everything was chaos." And you had one item that you had bought at an employee discount, and you ended up bringing two boxes with you. You returned one first thing in the morning, but you forgot to tell your boss that you'd taken it out and brought it back, and all of that stuff. The fact that they had to see a lawyer for that and it ended up um, all ended up that there was no charge, nothing was done. You know where I'm coming from? But the person had a consultation. The fact that the person even had a consultation, that itself is confidential. So you're not going to be able to give that name as a conflict of interest name when you go to a new law firm. Okay. But in the corporation context, it makes more sense because, you can look through a list of corporations. They may even provide one and say, yeah, during the time Claudine worked here, we worked for only 3 department stores and here's their names, and then so then if they want you, the new firm wants you to work on department store type cases, you know that you have no conflicts. And the wall would keep you out of, let's say, some other areas of law where you might have a conflict. And why would somebody even have a conflict? Um, because of having been a staff person. It's not because they're disloyal in the sense of being against and for the same person on the same at the same time. It's knowledge of secrets causes the subtle conflicts. Like I say, that example. Okay, person is charged by the city with having garbage on their yard. Very embarrassing charge because people in my area don't want to be accused of being dirty or unclean, or the fact that the person was ever charged is technically not really a secret, but it's a secret it's a secret from my point of view as a lawyer. And I'm not going to tell you which people have ever been charged with that. We did get the city, a couple of the little cities, to dismiss those cases without a trial or anything. The person didn't get their name in the paper at all. It's very embarrassing. Um, uh, and, but of course, we had to promise to clean up the yard right away and get everything spiffed up and by a deadline. And you know where I'm coming from? But the fact that that's in an old file, that knowledge, or supposedly in my memory, now I don't remember. I'm not wonderful with names, which actually helps. But, uh, you know, some things, like I say, just the fact that I knew that could create a conflict later on if I went back into law practice. If I went back into law practice and then got hired by one of the small cities to prosecute misdemeanors and so on, um, knowledge that I have from the past could give me an unfair advantage against somebody who used to be a client, even though they're not a client now. It's a subtle conflict, but if I have an unfair advantage, I can't be on the case. How does that sound, folks? Who has a comment about that? Just trying to help you conceptualize these things, the conflicts that are not so easy. Being against and or trying to be against and for the same person at the same time, to me that is totally common sense. The more subtle one, of just knowing something that would benefit your current client, um, that doesn't seem like a conflict, but it is, because it's a very strong form of loyalty. There's also, most of the time, if it's not super serious, most of the time, minor conflicts can be waived.
So
Um,
how how common is it for someone to not be able to work on a case because of conflict of interest, whether that be the attorney or the paralegal or anyone in the office, I suppose?
uh, it's fairly common in emotional cases like family law. Um, one of the um, let's say that um, let's say that I had done income taxes and had gone over stuff with a husband and you know done quite a bit of work with him about just income taxes. And then his wife comes to see me 2 years later after I stopped doing the income tax and wants me to represent her in a divorce. Um, Even though from my point of view, none of the things I learned doing the income tax would really be an unfair advantage, I would drop out of the case or I wouldn't take it. Do you see where I'm coming from?
Yes, yeah, that makes sense.
And because both sides eventually, at some point, both sides are going to think that I am a bad guy who is taking unfair advantage of one side or the other. The husband is going to think that I know about his hidden assets or something, or that I have a better idea of his business than I would. I wouldn't have that good of an idea, most of them, most of the business stuff. And the wife might think, well, um, even though he's representing me now, he was involved with and hey, from my point of view, I spent a few minutes doing a simple tax return for somebody, like a wage earner tax form for 1040. Um, you don't like spend hours going over it typically. I guess I spent more time than I maybe should have. I liked income tax for some reason, but you really don't learn all that much about somebody. But if there's a possibility that they're going to think so, I'm not taking the case. Um, I would probably not be willing to do an eviction against a former divorce client, even if the divorce client says, "Well, I'd rather have you get the money than somebody else," uh, you know, for doing this, and I can't pay the rent. They want to waive the conflict. I'm still going to tell the landlord to get somebody else. Now, I'm bringing these up because these are subtle things where another lawyer is going to say Olson is wrong. I want you to realize that when you take a job with a lawyer, there are times when you need to be able to say if Olson is not wrong, it's at least debatable. Okay. It's not about me being right and your boss being wrong. Okay. But I've stayed a point of view because it makes it easier to remember things. Okay. Are not the law. My points of view are not the law. They're an ability. I'm trying to give you a point of view to focus on and argue against. Okay. There might be a situation where the lawyer should go ahead and do the eviction as long as the former divorce client waives the conflict in writing. When I say waive the conflict, I don't mean casually, though. Um, Remember when I talked about getting legal advice in writing? Um, Conflict waivers, if anything, it's just as important, probably maybe even more important, but you want to save somebody's bacon so they think you should be an employee forever and should get a raise. Get those conflict waivers in writing. I don't want somebody, if a lawyer worked for me, I'm not going to listen to a lawyer who says, oh, well, I talked to the person's other lawyer and they said on the phone it would be okay, so they've waived it. Or I called her at work and she was in between customers, but she said, oh yeah, I waived that. Uh, I hope you wouldn't accept that as a paralegal. I hope you would put it in writing, ask the boss to approve it, and say, should I send it out or have the person come in, whatever. And I would do a formal conflict waiver form that fits what your state's lawyers use. My state bar association recommends doing one that reminds them to get another lawyer, even. If they have questions about the conflict and they want advice, you know, and frankly, most lawyers in my state would be willing to look at one for free, just for a conflict waiver. And they might say, no, uh, I wouldn't waive conflict, or I see where you're coming from. No, you can certainly sign a conflict waiver. That lawyer doesn't know anything. hasn't represented you for years and years. It's got nothing to do with what's happening now. Go ahead and waive it. Okay. But definitely waivers. I don't know if I put that into my slideshow. I don't think so. If you remember two things from this course, get legal advice in writing, have the lawyer sign it, and get the conflict waivers in writing, and do them according to your state's procedures, your state's best forms. Yay, you know. Those would be two things to take with you that are important. But here's an intake sheet for a new case with possible conflicts. This looks like a 3x5 card because it was based on 3x5 cards. Okay. Now, it's better to do these electronically now than just in a card file index. But there's no foolproof system. The reason the electronic forms, because of quantity, and probably, and it could add accuracy. But sometimes you still have to actually look at files to determine if there's a conflict. One of the problems, obviously, is the client name was Susie, but also Susan Paulson, Susie Morgan. And there was some consultation when she was using the trade name Susie in the AM for her radio show. You have to look up Frank Morgan. You know, and you have to look up the Sanfords and Melanie's name, because if you were helping the Sanfords with a similar real estate case, maybe you have an unfair advantage over the Sanfords, your law firm. So sometimes you have to look up more than one or two names. Okay. If Michael Johnson has a dispute, you'd have to look up him too. You're trying to find out what your law firm has done for or with any of these people in the past to get clues on whether there's a conflict. And I'm probably making it sound more complicated than it really is. Normally, you just look up the new client name and the and see if you worked for them before. And typically, that doesn't cause a conflict. But you look up the opposite party, the people that are against you on this one, and find out if you were for them before. And then you try to find out if anybody else in the law firm, and you can't always find that out through card file indexes, but that's where the electronic system comes in handy. But obviously, a lot of data entry has to be done to make the electronic system work. But was Melanie a client of the law firm that formerly employed paralegal Joan, who's in our law firm? Here's another example. Bob Anderson, attorney, represents the kids in a child protection case. And this has happened, these are cases I'm very familiar with. I was on different sides at different points in my career. I represented the county. Later on, I represented kids when I left the county employee. And later on, I represented parents and child protections. So I had to be very careful about conflict of interest, that the names were not from the same families, okay? And during the case, too, you have to ask yourself, as an attorney or a paralegal for the attorney, should the attorney who represents the children confer with the parents in private if the parents do not have their own attorney? That's a question that will come up fairly often. I would tend to ask the judge before doing that in today's world. Okay. And probably have the judge advise the parents that they need to get their own attorney, and if they waive having an attorney, that they're certainly welcome if they wish to talk to the lawyers in the case, like the one that represents the kids and the state's attorney, prosecutor. Okay. I'm going long again. I hope you folks don't mind. I'm doing my best here. So I looked up ethical wall in Minnesota state and federal court rules, and you should do it in your home state. But after I get one result, I'll use table of contents and scroll down to get more. And so I got this. Now, ethical wall maybe won't work in all states. You may have to start out with something more generic like conflicts of interest. There's a problem if you just use conflicts of interest, though. You might have to do conflicts of interest and attorneys at law, something like that, because there's so many different things called conflicts in the law. Again, if you know what you want, though, if you want your state's version of imputation of conflicts of interest, who can help you 24/7? Lexis. See where I put the Lexis Advanced Helpline, and I'll put it in the chat too. They're excellent when you know what you want. If you want to find ethical wall, imputation of conflict of interest, which is really what creates the need for an ethical wall. Imputation just is where one person knows something that is an unfair advantage, but it's imputed to everybody else in the law firm unless you can screen the person off. And for memory purposes, I think I'm gonna do for memory purposes, I think I'm going to do a whiteboard. So you say, let's say you have only one person creates a conflict. For the law firm. Let's say in this case it's Robert, okay? So everyone working on the case cannot talk to or work with Robert. So it's not really a wall. The wall is sort of a concept or sort of an analogy. It's sort of an analogy that everybody working on the case where there's a conflict pretends like there's a wall between them and Robert. So Robert cannot visit with those people or look at their files. and vice versa, they can't talk to him because they would find information that would be unfair. Questions, comments? So when you can't find this in your state, use Lexis Advanced Helpline and they'll get it for you. If you don't know what you want, they won't find it. But if they know you want rules of professional conduct, conflict of interest, they'll find something for you. I know they will. Try one state and then another. I had to change to client-lawyer relationship to get results in Florida. Then I scrolled down to conflict of interest. You see what I mean? It's not the same in every state. So client. Okay. So ethical wall didn't work in Florida. And I know you guys don't know the table of contents as well as I do, but you'll be, once you find one thing, you're going to say, every state seems to be similar to the model rules, and just about every state is, but they don't interpret them all the same. So you still need to be able to use the state. And the cases obviously are state, they're not there are no cases with the ABA. So we scroll down and we find out more. We get more information from different rules. At one point, I handled a case due to a conflict of interest. Now, they didn't even want to tell me because that itself was confidential, but I didn't understand why the prosecutor to the north of us could not have handled it. Because normally, if you can't handle it in Todd County, the Wadena County prosecutor would come down and handle it. But apparently, they had some kind of a strange conflict of interest. And even telling me what the conflict of interest was would have maybe breached confidentiality. They just said, they just had the judge call me, and the judge called and said, would you represent the state as a special prosecutor on a mental illness commitment? I said, yes, I will. Even though I was normally on the defense side, but I had to ask the name and then do a name check and make sure that the person and the relative that was pushing for the commitment were not on my former client list. Do you see why? Why did I have to look up the person's name that I was going to technically be against? I don't like to think of it that way. We're not committing somebody because we're against them. We're trying to get them help that they maybe don't want right now, but they will be better off in the long run. But you know, and I didn't like when my clients were being committed or they were attempting to be committed. I mean, I didn't counsel them. The state is out to get you. But my goal was to try to get them to be free and on their own as soon as they could, within reality, you know, within realism. But why did I have to look up the proposed patient, they call them, the person that was alleged to not be in their right mind? I had to look up that person's name, make sure that I didn't have any confidences or secrets from a former file for that person. And then I also had to look up the next of kin person who was asking the county to commit, and make sure I didn't have a conflict with either of those people, okay? And here's a quick quiz. If Joe, the attorney, says he got a letter saying he may be in trouble due to an alleged ethical violation he received the letter from A, the ABA, B, the disciplinary authority acting under the state's highest court, Supreme Court or appeals court, or the state's commissioner of commerce. Who do you think he got? Who did Joe the attorney get the letter from, do you think? A, B, or C? Anybody? Take a shot at it.
I'm going with B.
B is correct. A simple conflict of interest is imputed knowledge causing disqualification. When a lawyer is asked to advise someone that the lawyer is also suing for the same matter, B, or C. When a lawyer is asked to act on behalf of a person who has a personal grudge against one of the lawyer's office staff. Which is the simplest conflict of interest? They're all sort of conflicts of interest, but which is the simplest one? Easiest to make rules about? A, B, or C? Come on, folks, you know this one.
I'm going with C. I don't know if that's right.
Oh, that's not the simplest one. It's a good one, but B is the simplest. Advise someone that the lawyer is also suing for the same matter. So if I'm trying to collect for ACE Collection Bureau against Mr. Johnson, Mr. Johnson comes in and says, I can't pay, what are my legal recourses? I have to say, I'm sorry, but I'm working for ACE. You have to talk to a different attorney, okay? If somebody has a personal grudge against one of the lawyer's office staff, I don't believe that that's even a conflict of interest, but we might have to treat it as one just to keep peace. A personal grudge may have nothing to do with any case. So if it has nothing to do with a legal case, it's like, oh, you don't have to work with that person if we have a big enough staff. I did have somebody that didn't like my bookkeeper for irrelevant reasons that had nothing to do with law. So, you know, nothing to do with any knowledge or anything in the conflict rules. So that's kind of where I came up with that. The exception to confidentiality allows an attorney to disclose past crimes, plan future violent crimes, or information to defend the attorney from charge of misconduct or a criminal charge, or B and C. What I should say, exceptions, maybe. I'm going to answer this one, B and C. Past crimes, definitely we can't disclose that. Plan future violent crimes, you can. Information to defend the attorney on a charge of misconduct, you can. So B and C is the correct one. Form present opinions and test them logically and with research, or just research or just logically. Again, this is kind of an obvious one, but this is an Olson one. So I want you to form preliminary opinions on stuff and then test it out. That's what we do. It's not trying to memorize what I say. Some of what I say is even intended to just spark a little opposition because it's easier to remember things that you opposed. So my little, I used to be kind of against big law firms. I'm kind of more neutral now, but I kind of pretend like I'm really the same. You see where I'm coming from? Because it's to spark, it's to get you to test your own ideas logically and with research. It's not for you to absorb mine, okay? If you absorb my viewpoints, you aren't being educated enough. Then you know, I'm not saying I'm wrong about everything, but even if I'm right, I may disagree with your new employer. Okay. So you don't want to accept my stuff at face value. You want to look it up with research, test it logically. Thanks for working with me, folks. I know I kept you a long time. I appreciate Alyssa, Becca, Claudia, and Jennifer, Christina. Thank you very much.